Hello and welcome to this IP and Competition Law 3-part CPD cast series in which I'm joined by Treacy and Sophie Lawrance from Bristows. Pat is a partner at Bristows and specialises in EU and competition law. She also advises on the complex legal and policy issues that arise when competition law and intellectual property intersect. Sophie is an associate at Bristows and she specialises in competition law with a particular interest in working with businesses in technology and pharmaceutical sectors and in relation to the competition issues that arise in connection with standardised technology. This is the first of our 3-part CPD cast series discussing the relationship between IP and competition law. This part will begin by addressing the application of competition law to agreements and licences, including both block exemptions and the hardcore restrictions. Part 2 of this series will continue by explaining hardcore restrictions for VRBE and TTBE, the excluded restrictions, the Commission guidelines that accompany each of these block exemptions, and the drafting of licences and other agreements. The final part of this podcast series will then discuss standard essential patents. It will outline what is meant by fair, reasonable and non-discriminatory, and the application of Article 102 of the Treaty on the Functioning of the European Union. To begin with then, Sophie, can you briefly outline what intellectual property is?
Intellectual property law covers a number of different types of right. So it's essentially, the purpose is to protect invention or thinking that's been done by a particular creator. So to give a couple of the main examples, patents cover inventions. So if you've invented something new and that can be used industrially, then you may be entitled to a patent which gives you a 20-year monopoly, the right to keep others from doing that thing. A different type of right is copyright. So if you write something, a book, a work of art, draw something, paint something, then you will be entitled to copyright. That's a different sort of right because all it does is prevent someone else from copying what you've done.
And what is the purpose then, Pat, of competition law?
The purpose of competition law is a policy purpose really, and it does vary a little bit from jurisdiction to jurisdiction. But broadly speaking, the idea of competition law is to ensure that companies and businesses compete fairly in the marketplace. The idea being that if you have fair competition between businesses, that will deliver the best outcome for consumers and for society. So the idea is to stop companies either from agreeing together to do things that are anti-competitive, like fixed prices or rig markets, or if you have a company that's particularly powerful, to stop it from misusing its powerful position in the marketplace in a way that's going to harm other competitors and therefore ultimately consumers. And you can see this in the structure of competition law really throughout both Europe and the rest of the developed world. Most developed systems of competition law fall into 3 main parts, one of which mergers we're not going to talk about today, but the other 2, the first is to do with preventing anti-competitive agreements, and in Europe that would be Article 101 of the EU Treaty, and in America the equivalent would be Section 1 of the Sherman Act. Here in the UK it's Chapter 1 of the Competition Act, so you can see a symmetry across those jurisdictions. And then the other main aspect is stopping dominant companies or monopolies from abusing their monopoly position. And here in Europe you have Article 102 of the Treaty on the Functioning of the European Union. In the US the equivalent, and it's not quite the same but broadly similar, is Section 2 of the Sherman Act. And here in the UK we have Chapter 2 of the Competition Act.
Do IP and competition law then have similar goals?
At first glance, you might say no, because IP is all about stopping other people from using your invention, keeping people out, granting monopolies. So the owner of a trademark is allowed to stop anyone else from using that trademark. The owner of a patent can prevent others from copying its invention or using its invention. Whereas competition is about helping people to compete together, giving them access, allowing them into markets, opening markets up to competition. Looking at it another way, you could say that they have the same sort of underlying purpose, which is encouraging innovation. A patent does that by means of the grant of a monopoly right, which allows the inventor the ability to make money on the back of their invention, whereas competition law encourages innovation by ensuring that people don't misuse their rights and allowing them access to markets where it's fair that they should have that. So in some ways you could think about IP law is kind of the carrot of innovation, the reward, whereas competition law can be the stick. If someone misbehaves on the marketplace, the competition law can stop them from doing that.
Okay, so presumably then both IP and competition law intersect. Can you provide an outline as to when this intersection takes place?
Yes, I think Sophie's given a fairly good broad policy outline as to when this takes place. And if we just step back a little bit and think about how the two systems of law interact, it used to be thought in Europe that because intellectual property was a property right, that the European Union and the competition authorities couldn't intervene, because there was an article in the EU treaty that said that the property rights of the member states would be immune from interference by the competition authorities. And that gave rise to some trouble in the early days because people weren't quite sure how they could balance these two policy objectives. Over time, the courts and the authorities have tried to find a way of making the two systems work together. So, for example, there used to be a dichotomy where it was said that the existence of an intellectual property right was specifically a matter for national law, and that was a question of property. Whereas the way in which you exercised your right, if you did it, if you exercised your right in an anti-competitive way, that could be challenged in the same way as if you had a piece of physical property like a gun and you used it illegally to murder someone, well, it didn't matter that it was your property, it was still illegal. So that was a concept that people played with for quite a while. But of course, most people quickly pointed out that it was really a distinction without any significant difference, because what is the point of having a patent, the fundamental purpose of which is to exclude, if you sometimes can be stopped from using it to exclude people. So that distinction has slightly fallen out of use. What we now have is a distinction whereby the competition authorities accept that if you're doing something that's squarely within the specific subject matter of the right in question, then generally speaking, competition law will not intervene to control your conduct, except in some fairly unusual, exceptional circumstances. So again, in the context of a patent, the fundamental right is the right to exclude or to allow other people to put the product on the market under license. So competition law will not interfere with the decision to put a product on the market under license and to grant someone a license. But what it may do is say, well, once you've decided to grant a license, some of the restrictions that you might additionally impose could be subject to competition law. So those are the ways in which the two systems of law try to rub along together, and we'll give a few more examples of how that actually works in practice.
Okay, then moving on to Article 101 and looking at contracts and licensing, can you explain the precise ambit of this article?
Article 101 is the main central part of competition law in the way it deals with agreements between companies. Essentially, it prohibits agreements between two or more companies where those agreements have the purpose, the intent, or the effect of limiting or distorting competition on the market. There's also a requirement that there's an effect on trade between member states, and if you read that, you may think, well, what's that? But really that's just a jurisdictional point which is aimed at ensuring that EU competition law, as opposed to, say, a national competition law, applies. So what's the effect if there is such an agreement which has a restrictive effect on competition? Well, the effect, if that's genuinely the case, is provided for in subsection 2 of Article 101, which stipulates that your contract will be void and unenforceable, at least insofar as it does restrict or affect competition in that way. And that's obviously a very serious consequence for agreements, for parties who enter into commercial agreements, particularly where those are of high value or long-term, protecting their commercial interests. So that's the main reason why it's essential to be aware of competition law when you're dealing with contracts or licenses. Another reason, of course, is that, as people will be aware, the competition authorities often bring high-profile investigations and look at the way certain agreements play out between companies, and in serious cases can impose fines and other penalties. There's also a further element of Article 101, which is subsection 3. Now that is a bit of a get-out clause. If you have got an agreement which appears to restrict competition, there are a set of criteria in Article 101.3 which, if you meet them, allow an exception to be granted. I say an exception to be granted. In the olden days, as I could say, the European Commission used to actively grant exceptions. So you would apply and if your agreement met the criteria in Article 101.3, which are all about dissemination of benefits to consumers, ensuring that the agreement doesn't go beyond what it needs to achieve its aims and other similar points. So if you met those criteria, then you'd be granted an exception. Now, what we're going to look at later in this podcast are some of the ways in which you now have to make this assessment yourself as a party to an agreement. So it's important to understand the way in which these exceptions apply and how you use them in practice.
Well, following on from that then, Sophie, how is IP exploited and when might Article 101 apply?
IP can be dealt with in a number of different ways. As the IP owner, you can simply use it yourself. For example, as a patentee, you can work your invention and make money out of selling the goods or services that ensue from your invention. As an alternative, once you've invented something, if you're an R&D company, you might apply for a patent, but then you might decide to sell it, and that would be an outright assignment. And in both of those cases, where the company is just using its monopoly rights itself or where it sells them, it's very rare that competition law intervenes, and this comes back to what Pat was saying about the specific subject matter of your patent rights or your other IP rights. Another possibility is that you might decide to appoint a licensee, so get someone else to do a bit of the work for you and perhaps certainly derive some income from that. Again, that's part of the specific subject matter of the patent, so generally that doesn't raise issues, except when, as Pat mentioned earlier, you put in place additional restrictions around the pure grant of a licence, which could give rise to limits on competition that go beyond what may be perceived as necessary to protect the grant of the licence. What types of licence might you grant? Well, you could grant an exclusive licence. You give away your rights entirely, subject to termination of the licence, to a licensee. Or it might be a sole licence, so you as the owner of the IP retain the rights to work the invention, but you also grant the rights to someone else, either, for example, in a particular territory or for particular customers. Or it can be a non-exclusive licence. In general, as we'll see as we go through this, the more restrictions and limitations that are placed on the licensee, the more likely it is that competition law may apply.
Which clauses should be approached with particular care when licensing then?
So anything whereby, if you were the licensor, if you're wanting to put in place a restriction on the licensee, so for example, if you were to tell the licensee which customers it can sell to, or to say you may not sell to particular types of customers, or if you were to prevent them from launching the product in particular territories. One aspect of EU competition law that we haven't mentioned yet is the importance that's placed on the single market around the EU. So, for example, if you were to grant a licence only for a licensee to use the rights in France, and you were then to try to prevent them from allowing their goods to be exported from France to Germany, then that would be a restriction of competition because it would infringes this sort of single market imperative, which is allowing goods and services, once they've been placed on the market, to move freely around the EU. Having said that, there are a vast number of clauses that would appear in typical licence agreements that don't raise any issues. So, for example, prohibiting sub-licensing is not generally problematic. Generally speaking, the way restrictions tend to come about is where one party maybe has a little bit more bargaining power. The party which owns the IP would often have something to offer, and the licensee may find that they are having difficulty in negotiating as open a licence as they would like. So in that circumstance, the licensor may put in place certain restrictions that limit what the licensee can do and maybe go beyond what is acceptable under the competition rules.
Moving to the exclusions to Article 101 and its prohibition, Pat, can you outline the exemptions that are available?
Yes, I mean, I think exemptions is a pretty broad phrase, but there are a number of ways in which common commercial agreements can fall outside the scope of the prohibition in Article 101. And the first and most obvious is that, of course, to fall within Article 101 in the first place, you have to show, or there has to be a showing, that there is an appreciable effect on competition. So if, on balance, the licence in question doesn't give rise to an appreciable effect on competition, then Article 101 really won't apply in the first place. And a very good example of that would be what's known as an open exclusive licence. So if a licence is granted and the only restriction on competition is that the licensor agrees that he will not grant another licence in the same territory to another licensee, it's quite possible that that won't fall within the scope of Article 101 at all. There was a very famous European Court of Justice case called the Mersey case, which held that could very well be the case. And the reason the court held that was by looking at what the alternative would have been. It's what competition lawyers call the counterfactual. And the Court of Justice said, well, if you look at the situation in question, it was a new technology, and the licensor was attempting to encourage the licensee to take a license in a territory and to exploit the technology and bring it to the market. But of course there are risks involved in that. And the licensee said, well, look, I have no interest in taking on this risk if I'm concerned that you or someone else is going to come in and compete with me as soon as I have invested in the market. And the Court of Justice said, well, in those circumstances, you really don't have a restriction on competition at all, because the counterfactual is, the sort of alternative universe, is that there would not be any exploitation of that technology in that territory. So that's one example of where Article 101 might not apply. Another situation where there may be no appreciable effect on competition is where the parties are either too small, too insignificant, or their market share isn't sufficiently large to give rise to an appreciable effect on competition. And that, of course, can be a difficult thing to assess. So what the European Commission has done is to issue some guidelines. It's the Notice on Agreements of Minor Importance. And that tells us which sorts of agreements, generally speaking, will fall outside the scope of the prohibition in Article 101. There are also things called block exemption regulations, which we'll talk about in a little more detail shortly. And a block exemption regulation essentially describes a common form of commercial agreement and tells you that agreements of that sort will usually be acceptable under Article 101 as long as they don't contain certain hardcore restrictions on competition and as long as the parties to those agreements aren't very powerful, so they don't have very, very substantial market power. Article 101.3 has already been mentioned, and that's where you get an automatic exception from Article 101.1, but in order to do that you have to satisfy certain criteria, which we can talk about a bit more in a minute. And one of the reasons why Article 101.3 is a little bit less used than the block exemptions is that the applications of the criteria are quite difficult and require a lot of information and often some quite sophisticated economic analysis. So Article 101.3 can be quite difficult to rely upon. And finally, although not strictly speaking an exception or an exemption, the European Commission has issued a series of guidelines which tell us how the competition rules apply or should apply to intellectual property agreements. And I think if all else fails, that's often a good place to go and look and see if you can get some help in analysing the particular type of contract that you're dealing with and get an indication whether it's likely or not to give rise to significant problems under the competition rules.
Okay, so you mentioned the Notice on Agreements of Minor Importance. Can you just explain what these are?
Yes, I can. The Notice on Agreements of Minor Importance was published by the European Commission some time ago. And the purpose of the notice is to provide some guidance as to the agreements which the Commission thinks are generally likely to be sufficiently small or unimportant that the prohibition in Article 101 simply won't apply. And what the Commission has done is said, well, agreements are likely to be in that category for one of two reasons. Either the parties don't have a very big market share, so they don't have much market power. And as you'll realise, the competition rules get more and more interested in your conduct, the bigger and more powerful you are. So that's the first criterion. Or alternatively, the parties are inherently quite small. So if you have agreements between two small or medium-sized companies, the European competition rules may not be interested if you're what they call an SME, a small or medium-sized enterprise. Now, looking at the market share thresholds, for the Notice on Agreements of Minor Importance to apply, there are different market share thresholds that might apply depending on what sort of agreement you have. So if it's a horizontal agreement, so an agreement between two companies who are at the same level in the marketplace, if they have a 10% or greater combined market share, then unfortunately they can't take refuge under the shelter of the Notice on Agreements of Minor Importance. On the other hand, if you're talking about a vertical agreement, so an agreement between companies who are different levels in the marketplace, and a classic example of this would be a licensing agreement or a distribution agreement between non-competitors, then as long as neither party has a market share of 15% or more, they can take refuge under the Notice of Agreements of Minor Importance. There is one final category which doesn't often really get referred to, and that's if you have an agreement which is of a type that's very common within that particular industry. So there's a network of similar agreements. And one example of that might be the sort of tied pubs agreements that you get in this country, where a publican may become a tenant of a big brewery company, and in return for certain benefits, such as a lower rent, they agree to sell just one or two types of beer. So that's a tied pub agreement. Because many, many pubs in this country are let on agreements of that sort, it's quite conceivable that the market share for networks of agreement would apply to an arrangement like that. The market share threshold there is 5%. Finally, and I think this is an important point, even for very small agreements or agreements between small companies, if that agreement contains a restriction on competition that's known as hardcore, so a really serious restriction on competition, the sort of provision that is going to get any competition lawyer excited, then unfortunately the notice on agreements of minor importance won't apply. And the sort of restrictions I have in mind there are things like price fixing, market sharing.
So you mentioned block exemptions also. What is the primary aim of block exemptions?
The idea behind a block exemption regulation is to give some form of safe harbour for companies. Earlier on in the podcast, I talked a little bit about the difficulty of applying Article 1013. It's quite a complex analysis. The concept of a block exemption regulation is it looks at types of agreement which the Commission has decided are normally, on balance, pro-competitive. And it says, OK, for agreements of this sort, then as long as they don't contain certain very restrictive provisions on competition, and they're not between very large companies, we think that as a mass they can just be exempted. We're not interested in them. And the sort of agreement that you might have in mind there are things like exclusive distribution agreements. The Commission recognises that sometimes it makes perfect sense to appoint an exclusive distributor, because they will be willing to invest in your products, you'll be able to concentrate your efforts on them, and that should result in better quality and service for consumers. So those are very common types of agreement, but they do equally contain restrictions on competition, because you can only appoint one distributor, and often they can only sell of a particular type of product, your brand. So there are two restrictions on competition straight away. But nevertheless, the Commission says because those restrictions are sensible and proportionate for the type of agreement that you're entering into, nevertheless, they're block exempted and they fall outside the scope of the prohibition in Article 101 entirely, as long as you comply with the requirements of the block exemption regulation. The point of a block exemption, as I've said, is a safe harbour, and therefore they should give a degree of legal certainty for companies. That doesn't always happen for reasons I'll explain in a moment, but perhaps it might help if I just talked about how block exemptions are structured, because that may help to give people an idea of how they work. Every block exemption regulation is structured along broadly the same lines. You'll have a description of the type of agreement it's supposed to cover. So there may be a block exemption for vertical agreements, a block exemption for research and development agreements, a block exemption for technology transfer agreements. So it tells you what it covers. It will then tell you that there are certain market share thresholds, and the block exemption is available only to agreements where those thresholds are met. It will then set out a list of so-called hardcore restrictions. If you have a hardcore restriction in your agreement, the block exemption will not apply at all, not to any restriction in the agreement. Those are the sort of clauses that are the real no-nos. They are to be avoided if at all possible. Makes your life a lot easier. There are then the so-called excluded restrictions. These are restrictions which are regarded as potentially problematic, but they can be justified in some circumstances. If you have an excluded restriction in your agreement, that particular restriction will need to be justified, and it's not exempted. But any other restrictions on competition, as long as they're not hardcore, will be exempted. So that's quite an important distinction. I think it's worth pointing out that the way in which block exemptions now operate is that if you're within the scope of the block exemption regulations, you've got the right type of agreement, and you satisfy the market share thresholds, then as long as you don't have a hardcore restriction and you don't have an excluded restriction, your agreement is fine. So it's a sort of blanket coverage. One of the problems with modern block exemptions is that the Commission is trying to make them more realistic. and therefore it has decided that if you have agreements between very powerful companies, that they really shouldn't benefit from a block exemption regulation, because you can't really assume that on balance they'll be good for competition. So they've inserted various market share tests, as I mentioned. The problem with market share thresholds is that inherently they are uncertain, because first you must define your market, and then you have to work out what your market share is. And that can sometimes be much more difficult than you would think, particularly if you're talking about complex markets or small markets or technology markets. So although the whole point of a block exemption is to provide certainty, sometimes that certainty is more of an illusion than you would necessarily think. I think the other thing to bear in mind is that sometimes it can be difficult to decide which block exemption applies. And in order to do that, you need to really look quite carefully at the scope of the agreement you're entering into and which block exemption is really going to be the right one for that agreement. Generally speaking, not always, but generally, if you're looking at an agreement which deals with the licensing of intellectual property, you're most likely to be looking either at the technology transfer block exemption, the TTBE, or the vertical restraints block exemption, the VRBE. Occasionally, you might be looking at the research and development block exemption, but the other two are more likely to be the prime candidates.
So, Sophie, when does the VRBE apply?
So, as the name suggests, the vertical restraints block exemption applies to vertical agreements. Now, what is a vertical agreement? Essentially, a vertical agreement is one between companies that are at different levels of the supply and distribution chain. So, for example, a supplier which manufactures goods will sell them downstream, as it's called, down the distribution chain, to wholesalers or distributors who will then sell to consumers. So when Pat was mentioning the scope of the block exemptions, the scope of the agreements block exemption or the vertical restraints block exemption is that it applies between companies at different levels of the supply and distribution chain. Now that doesn't sound like an IP agreement, but if you think about trademarked goods, an agreement whereby a supplier sells or supplies goods to a distributor will tend to often involve the need for the distributor to use the brand when selling goods to consumers. So in those circumstances, there may well be a trademark license together with the agreement to supply goods to the distributor. In that case, which block exemption is going to apply? Well, provided the trademark agreement, in this case the trademark license, is purely related to the ability of the distributor to put the goods on the market and to use the trademark in connection with that, then the licence will be covered by the vertical restraints block exemption, assuming the main agreement is covered itself. So the vertical restraints block exemption is designed to cover certain IP aspects, provided they're not the primary object of the agreement, and provided that they're directly related to the goods or services which are being supplied under the agreement, which is protected by the vertical restraints block exemption.
Is then the TTBE still relevant?
Absolutely. If you're looking at pure licensing, the TTBE is the key. The TTBE, in terms of scope, the TTBE covers agreements that relate to patents and software copyright and know-how. Other sorts of IP, if it's a pure IP license of, say, other copyright or trademarks, they're not covered directly by the technology transfer block exemption because, as the name suggests, that's to do with technology types of IP where the technology is being used in relation to goods or services which ultimately come to market. And that is another aspect of the scope of the exemption. The technology transfer block exemption only applies to licenses which enable the production of licensed products. So, for example, you might consider the case where a patent is being licensed to allow a licensee to use it in its technology in order to manufacture some goods. In that case, the agreement, subject to all the market share thresholds that Pat has talked about, in that case the agreement would be covered by the technology transfer block exemption.
Pat, can you provide some brief points of comparison between the vertical restraints block exemptions regulation and the technology transfer block exemption?
Yes, I mean, the principal distinction is really, as Sophie said, what type of agreement you're talking about. But once you've decided which applies, there are some quite notable distinctions between the two block exemptions. I think one of the primary ones is that As far as the VRBE is concerned, agreements between competitors are excluded. So an agreement between competitors won't be covered by the vertical restraints block exemption. Under the TTBE, by comparison, certain agreements between competitors will be exempted, although they may be subject to more demanding market share thresholds, and certain restrictions will be treated quite strictly. Nevertheless, it's an unusual circumstance where competition law actually permits agreements between competitors which contain restrictions on competition. So it's quite a generous block exemption in some ways. I think the other principal difference between the two is in relation to the market share thresholds. The vertical restraints block exemption has a single market share threshold, which is 30%. So as long as neither the suppliers nor the purchasers' market share exceeds 30%, then the block exemption will apply. The technology transfer block exemption is more complex in that it has two market share thresholds. If you have a technology transfer license between non-competitors, then the market share threshold is 30%. So it looks like the VRBE. On the other hand, if the agreement is between competitors, then the market share threshold is 20%. So it really does demonstrate the much more rigorous approach to agreements between competitors, which you would expect to find under most competition regimes.
What are the hardcore restrictions for both the VRBE and the TTBE?
This is not as straightforward a question as you might think. The VRBE hardcore restrictions are reasonably straightforward in the sense that it permits many restrictions on competition, but is very aggressive in prohibiting certain forms of price restriction. So resale price maintenance, where a supplier tells his distributor the price at which he can sell on to third parties, that is a hardcore restriction. It is permissible to have a maximum resale price. So if I'm a supplier, I can tell you not to sell at more than £10 a kilo, but you can't have a minimum resale price, i.e. you can't sell it less than £8 a kilo. If you think about it, that does in some ways make sense, because if I'm telling you not to sell it more than £10 a kilo, that's protecting consumers from any form of price gouging. Whereas I'm telling you not to sell it less than, well, that's actually an attack, a direct attack on a principal form of competition, which is competition on price. So that's a hardcore restriction. Territorial restrictions are dealt with by the vertical restraints block exemption. It's quite a complex story. So certain restrictions on territorial resales are permitted. And in particular, I can stop my distributors from actively selling into a territory that I've reserved to another exclusive distributor. Now, the key point there is the word active. So if I've given you, let's say, France as your exclusive territory, and I've given someone else Germany, it's perfectly all right for me to say, I want you to concentrate on France. That's your job. I don't want you advertising in Germany. I don't want you setting up a distribution network in Germany. You concentrate on France. What I can't do, however, is say, oh, and by the way, if any German comes across the border and wants to buy from you and take the product back to Germany, you must say no. That's passive selling, and passive selling must always be permitted. So you must always be free to respond to an unsolicited request for sale. You don't have to supply if you don't want to, but I can't make you refuse to supply. And that's something you'll come across very often, both in the technology transfer and in the vertical restraints block exemptions. There are also certain particular restrictions to do with selective distribution networks, which probably aren't that relevant when we're talking about IP particularly. If you look at the TTBE by comparison, you'll recognise immediately that some of the hardcore restrictions are exactly the same. So restrictions on resale prices, or the prices at which you can sell downstream, those will be hardcore, irrespective, TTBE, VRBE. As far as the territorial restrictions are concerned, those are somewhat more generous than under the vertical restraints block exemption. But, and this is a very important point, the list of hardcore restrictions is much longer if you have an agreement between competitors. If it's an agreement between non-competitors, actually, the list of hardcore restrictions in the technology transfer block exemption is really quite short. But once you have an agreement between competitors, it becomes much longer. So, for example, any form of output restriction is going to give rise to potential concerns. Various non-compete restrictions will give rise to concerns.
Well, Pat, if I can stop you there and if we can continue to deal with hardcore restrictions for both VRBE and TTBE in part 2 of this podcast series. In part 2 of this 3-part series, Pat and Sophie will discuss hardcore restrictions for both VRBE and TTBE, the excluded restrictions, the Commission guidelines that accompany each of these block exemptions, and the drafting of licences and other agreements. That concludes this CPD cast.